Hi, Kelly. Hi, Neha. How are you, ladies?
Good, how are you?
Doing
I'm
great. So great to see you.
great to see you too, Neha. This is not your first time on this YouTube series for Wicked, but it's always nice to see you again. And Kelly, welcome to
Thank you.
the series. So I will. Well, today we're going to be talking about something really important. I know it's been stressing out a lot of people, including myself. It's the new requirement from the Law Society for succession planning for those of us who are in private practice, like Neha and I, for example. I know I'm stressing out, and I would really like to hear directly from people from the Law Society about that. And you two are working with the Law Society, so you are the perfect guests to tell us more about this. But before we get into that, I would like you ladies to introduce yourselves.
Do you want to go first, Neha, or
Well,
do
sure. For some reason, I keep getting invited back to these things, despite my flaws. I'm Neha Chugh. My practice is in Cornwall, Ontario. I service most of Eastern Ontario. I am a criminal defense lawyer first, but I do some family law and a little bit of child protection law as well. I'm very happy to be here, and it's my favorite group of people. So thank you for having me.
And you're a Law Society bencher, you forgot to
Oh,
mention.
yeah, I forgot that one piece. I'm an elected bencher of the Law Society of Ontario. So I'm one of a small group of criminal defense lawyers who are elected benchers. And I'm also a small firm owner. So I started as a solo practitioner, and now we are a group of three lawyers working together. So this affects me. Probably not in the same way that it affects Maya, because Maya's on her own. There's different implications for different structures of firms, but this does affect the criminal defense bar in a way that I'm really glad we're opening this discussion about.
Thank you.
excellent. Me here. I'm really excited to have my first time here on the YouTube channel. I'm going to tell my kids I'm a YouTube star after this, and they'll be very excited. So I'm a lawyer and a manager at the Law Society of Ontario in the Practice Supports and Resources Department, or PSR for short. We love acronyms at the Law Society. I'm sure you've already figured that out, Neha. So in PSR, our real focus is on providing licensees with various tools in different formats and supports that they need to handle their professional responsibilities confidently and also manage their practices responsibly. So we do that in several ways. We create resources in varying formats. We present at different programs like this today. And we also provide ethical guidance through our practice management helpline. And I've been with the Law Society for about 7 years. And for the past 3 years, I've been the manager of the Law Society's practice management resources, which, if you don't know, are free on our website to all licensees. And in terms of my background, before joining the Law Society, I was a director at LexisNexis, directing their Lexis Practice Advisor product, which is an online practical tool for lawyers. And then prior to that, I practiced constitutional administrative law as well as commercial and securities litigation at two national law firms. And that's me.
Well, thank you, and welcome to both of you once again. So let's dive now into the topic that brings us here today, and it's about this new requirement for succession planning for lawyers in private practice. So let's start though by talking about why do we have this new requirement?
Yeah, so I think that's a really good question because I think it's if you understand the why, then it may be actually easier to carry this out. So the new client contingency planning requirements really aim to address a critical issue in the legal profession that can directly and seriously impact your client interests. So over the past 10 to 20 years, there's actually been a significant increase in the number of practices, and particularly sole practitioners, that require the involvement of the Law Society's Trustee Services Department because they have failed to plan for sudden or unexpected events. It's also anticipated that this trend is going to continue because of the aging bar. In fact, I think in the report it says between 2005 and 2020, so about 15 years, there's been a 240% increase in the number of sole practitioner lawyers over 65. So we can anticipate, as the aging population, that there's greater risk for illness or accident, things like that, and unfortunately even death. And the concern, while the trustee services department is there in part to fulfill this type of role, the concern with relying solely on trustee services in these situations is, I think, in my opinion, twofold. So first, it's actually really quite costly. The trustee services budget has doubled over the past decade. So now it's, I think, $2 million per year. And it's anticipated to rise because of the aging population and more people falling part to this, which of course could then lead to increased annual fees for all licensees, and nobody wants that. So that's partly the reason. And then the second, and I think more importantly, is that it can actually take weeks for trustee services to step in and notify clients, which especially I think in the criminal context really puts their legal interests and rights at risk. And that's often because trustee services doesn't have the information that they need to intervene immediately. And so it takes a while for them to access client files, access trust funds, and get those back to the client so that they can seek new legal representation if you are suddenly unable to complete their retainer. So without proper planning, you really risk leaving your clients as well as your staff, your practice, and families, because in most cases, it's the family member who has to step in and deal with the practice, and often during a very difficult time or a vulnerable situation. So I think that's why it's really important to have this new requirement, particularly for sole practitioners where there isn't another person in the firm who can step in if needed. So, if you imagine for a moment that both of you, for example, have a client who's facing serious criminal charges, let's say the trial is about 2 weeks away, and unfortunately on your way to meet another client, you're involved in a serious car accident and fall into a coma. You will eventually recover, so everything's okay, but the doctor informs your family that you won't be able to work for several months. If you have an assistant, they have no idea where you are. Your family doesn't really know much about your practice. So the trial date's approaching, your client thinks their case is being monitored, but it isn't. And they're getting increasingly stressed and anxious, having heard nothing from you or anyone else, which is really unusual. So I think, it's very easy for all of us as humans to say, well, that won't happen to me. But I think if we remember COVID-19, we can all appreciate that unexpected events do and can happen and can completely catch us off guard. So I think with these new requirements, the good news is that with just a few steps, you can ensure that you're prepared and your practice and your clients are safeguarded whenever life throws you a curveball.
And in criminal law specifically, I know Neha can also comment on that. I mean, what we've been seeing is a lot of, especially female lawyers, have been leaving the profession. So that would also include the situation where they're quitting the practice of criminal defense. So what will happen to the client in that?
Exactly. Mm-hmm. Exactly.
So then, who does this specifically?
Yeah, so it's, as I said, it applies to all lawyers and paralegals in private practice. So all of those lawyers and paralegals have to have a client contingency plan. And for the reasons I've said already, it's really aimed primarily at sole practitioners or sole shareholders of a professional corporation because they're effectively a sole proprietorship. It would also apply to licensees who are effectively on their own as a sole practitioner, and let's say they're contracting their services to other licensees or firms. It could also apply to licensees who have their own sole proprietorship but share office space with another licensee, or who work in association with another licensee. So effectively, if you're a sole proprietorship, sole shareholder of a professional corporation, then this applies to you. There are some exceptions. So first, in-house counsel or licensees are not required to have a plan. Neither are licensees who provide legal services through all levels of government and through a legal aid clinic that's funded by Legal Aid Ontario. And then as well as licensees who are in non-practicing status, although once they move back to practicing status, then they will be required to have one. And if you're a partner or associate in a firm, so this may be more the situation of Neha, is that you're not required to have an individual client contingency plan, although you can, and it may make sense depending on the circumstances. But because you are a licensee in private practice, you will be required to confirm in your annual report that your firm has a plan that meets the client contingency requirements, and that plan also includes a contingency in the event that none of the members of the firm are able to carry on the professional business. So let's say you do a partners retreat, because we all have all this money to go abroad and spend time, that unfortunately you all fall ill or are unable to continue the business or get into an accident. The plan must have a contingency for that event.
So it's more work for those who already have a lot of work.
Exactly.
Okay.
Yes.
But does this requirement also apply to closed files, or is it only for the active files or open files?
So in terms of administering the plan, your appointed administrator is only required to deal with active clients. So notifying active clients that you're no longer able to complete the retainer, whether that's temporarily or permanently, and then obtaining instructions from them in terms of the return or transfer of their files and funds. That said, the bylaw does require that you include information in your plan on the location of and access to all client files. So that includes open and active as well as closed files. But I think it's important to emphasize that while you have to include all that information, your administrator is really limited to 3 roles, which we'll get into. And so they're not required to act on all that information. So that said, for compliance purposes, it has to be included, but your administrator is not acting on all of that information, just primarily dealing with active client files.
Okay. In terms of compliance and reporting, how do we demonstrate compliance with this requirement?
Yeah, so the good news is that the bylaw comes into effect on January 1st, 2025, but you don't have to have your plan in place and finalized by then. In terms of reporting compliance, that starts with your 2025 annual report, and then annually thereafter. So effectively, that's by March 31st, 2026. You have to be able to report that you have a plan that complies with the requirements. Or if you're a partner or an associate, that your firm has a plan that complies with those requirements. And I haven't seen the updated annual report filing yet, what it looks like, but in terms of compliance and ensuring that, if you got a random spot audit or a practice review, I would suggest taking a couple of steps. So first, ensure that your client contingency plan is written, whether it's an electronic document or in paper copy, and that it's stored in a secure location, so an encrypted file or in a safe, for example. You also are required to review your plan annually, so I would recommend including a created on or a last review date or both on your plan, so that you can show that it has been reviewed annually. And then make sure that it includes all the information bylaw 7.1. And then most importantly, obtain the consent of your plan administrator. So that you don't have to enter into a formal agreement. They don't have to sign your plan or anything like that. But as a best practice, you should either get their consent in writing or confirm their consent in writing, whether that's by email or whatnot, just so that you have a record of that.
Okay. And when does the reporting on this begin?
Yeah, so the 2025 annual report is when you'll have to check the box that says I've complied. Similar, I guess, to when we had the statement of principles. Yep. Yes, I've done that. And so again, that's by March 31st, 2026. So you effectively have the full year to put your plan in place, find an administrator, and make sure you have all of those arrangements.
Okay. So now if we go more specifically as to what lawyers are expected to be doing.
Yeah. And I love this question because this allows me to clarify, because a lot of the discussion in the legal profession is, oh my gosh, I have to have this full-blown succession plan or business continuity plan where I have to find a replacement lawyer to come in and take over all my files. And that may have been initially what was contemplated and put forward to convocation. But after consultation with the profession, those requirements became much more narrow. So in a nutshell, you have to have a client contingency plan that appoints one or more licensees to be your administrator. And your administrator is obviously the cornerstone of your plan. The only requirement is that your administrator be a licensed lawyer or paralegal, preferably someone you trust, but they don't necessarily need to be in your specific practice area. And when I discuss the requirements a little bit more, you'll get a better sense as to why. So in terms of selecting an administrator, this could be a person who is retired but still has their license, so they're still a licensed lawyer. It could be an associate that you hired to support your sole proprietorship. It could be a colleague that you have from law school that you're still friends with and trust, a licensee who maybe you used to work with. It could be a licensee mentor or coach that you have, or even a member of the same legal organization. So Wicked, for example. So it really is a broad spectrum. And as I was saying earlier to Maya, you can also have your plan administrator supervise a non-lawyer to administer your plan. So if you have a legal assistant or a family member who is familiar with your practice and someone that you obviously trust, it may actually be preferable for you to have your appointed administrator supervise them. So you still need to appoint a licensee as an administrator, but they can supervise this non-licensed in carrying out your plan.
Okay. Neha, you're going to be my appointed.
That's what she was saying.
Well, I learned something new every time I do one of these videos. You know what this kind of reminds me of is, you know, my mom used to say, you know, wear your good underwear because you never know when you're going to get hit by a truck, right?
It's true.
Yeah, that's what this reminds me of.
Yeah, and it's funny because I was preparing for this and I actually got rear-ended on the weekend, and I'm always the type of person who's like, this is never going to happen to me, and it wasn't anything serious, but in that moment I was like, see, it can happen to anyone. So it really is good to be prepared. So the second thing in terms of the plan is, as I keep saying, it has to include all the information that's mandated by bylaw 7.1. So that would include location of and access to open and close files, as well as any original property, location and access to your accounting and bookkeeping records, passwords to software, other technology, etc. And again, the administrator doesn't have to act on all of those pieces of information. They're really limited to 3 things, which I'll get into next, but it does need to be included for compliance purposes. And one question I keep getting is that, you know, some licensees, including myself, are quite apprehensive about or hesitant to share really personal and sensitive information like passwords or bank account details. So what I'll say is that while you're required to include that information in your plan, you can still comply by indicating where those passwords are stored and who the administrator can contact to gain access. So if your passwords are in a safe, you can say, hey, they're in a safe, and you can contact my mom or you can contact my assistant to gain access to that information if the time comes that you need to step in. And then finally, and most importantly, the plan must require and the administrator must agree to take certain minimum steps. So you can always get them to do more, but they have to agree to do at least 3 steps. So the first one is to notify the Law Society and your professional liability insurer that you are no longer able to practice, whether that's temporarily or permanently, and advise that you are the appointed administrator. In terms of notifying the LSO, you are all aware of LSO Connects, so that's the way that you're going to be doing that. So you're going to go into your own LSO Connects as the administrator. You're going to click the Trustee Services tile, and then you'll start a new inquiry form and advise them via that form. The second thing that the administrator has to do is inform clients, active clients, that you are no longer able to complete their retainer, and then obtain their instructions on the transfer or return of their files, including any client property and remaining trust funds. So if you have a trust account, the third thing they must do is attempt to access your trust accounts for the purpose of returning trust funds as per the client's instructions. So those are the only steps required by bylaw 7.1. but depending on your practice, you may want your plan administrator to do more. So for example, you may want them to notify the court or Legal Aid Ontario if you're doing a lot of legal aid work. Or perhaps if you have staff, you want them to access your general account to manage staff wages, etc. That's all up to your discretion. What's required is just those three things: notify the law society and the insurer, notify your clients, and get instructions on returning their property and trust funds. And as part of that, accessing the trust account.
Okay.
And I think, Maya, we had talked about how, and other people have raised too, like you may have specialty areas or offer services in different languages, and you can include those additional instructions in your plan to ensure that your clients are properly supported. So, for example, if you, in the notification email or letter that the administrator sends, you could indicate in there that they should, for this client, I'd like you to refer them to these lawyers because they have, this experience or can speak this language, or it's a niche area of this practice. So things like that. So you can add details to help support your administrator and essentially safeguard your client's interests.
Okay. Now, what I do want to ask here, and that's, I think, going to be useful for a lot of us, are there precedents or resources to help us, especially because this is something very new, and I don't think many of us already have such a plan, and we don't know how and where to start.
Yes.
So I hope that there are resources.
Yes, yes. So there are resources. And as I said, PSR is responsible for putting out a lot of these. So we work very closely.
Yeah. Not a pre-sentence report, because in criminal law, PSR specifically.
Oh, sorry. Yeah, so practice supports and resources. Our department, that's partly what we do, is create resources. So we worked closely with policy and trustee services, and we developed resources. So there is an optional template, which is customizable in Word. So you can go to our website and download that. And it has all the information required by bylaw 7.1. So you just have to fill in the details, or you can start from scratch. Or if you already have a succession plan, then just make sure your plan includes those minimum requirements, which is basically, somebody who's going to notify the law society, insurer, and clients. We also have step-by-step sort of infographics. We also have a checklist of guidelines. So basically for both the planning licensee and the administrator to help limit liability and make sure that you're fulfilling all of the requirements. In terms of trust account access, we also have a sample power of attorney Word template, and we have a sample letter from the administrator to your active clients. So you can also all in Word, so you can download them and customize them easily. And then finally, we have some answers to some of the common questions that we've been receiving from licensees on these requirements. And I think our CPD department is working on developing new programming as well, which will be launched next year. So there'll be additional information, and I imagine there'll be a lot more questions. So at that point, it may be good to kind of participate in that to see if any of your unanswered questions are now addressed. So yeah.
I don't know if the CPD programs are going to be free, because I think, well, the losses like to charge a lot for these events, but I think this is going to be something that a lot of us will want to attend. Are there free ones?
I would imagine so. Like, I know when we fill an to sports and resources, when the AML requirements came out, we did a free program on that. So I would imagine usually when it's a requirement and helping licensees understand what those requirements are, they are generally free or at a low cost. So I don't work for CPD department, but I imagine that would be the case with respect to these requirements. Yeah.
I hope both of you will strongly
Yes.
recommend the CPD department that they offer at least a few of them free for our members who can't afford to pay for the law society.
100%. 100%. I will definitely speak to them about that for sure.
Thank you. Okay, so are there updates that are required? Like, how often do we have to do this? Or
Yeah, so it's not a set it and forget it kind of task. You do have to review it at least once a year. So I would recommend blocking time in your calendar, because you're also very busy, to make sure that you spend the time to undertake that task. And I mean, the review may be as simple as, nothing's really changed in my practice. My administrator is still good to go. it's good, but I've reviewed it and nothing's changed. But as your practice grows, 10 years out, et cetera, you may want to make changes to your plan and make sure that it evolves as your practice evolves. Or if unfortunately your administrator is no longer able to assist, then appointing another one, which is why it's always good to have a backup. But I understand it's already hard to find one person. But yeah, those are the reasons why it's required that you review it at least once a year.
Okay, so we need a backup for the backup.
It says appoint one or more licensees. So the requirement is at least one. But I think because you never know what's going to happen, it's always best to have two, so that if, one can't, then at least you already have another one and aren't scrambling to find somebody at the last minute.
So Nehas, you and someone from your firm, please.
I have a question. Is this something that we should be writing into our retainer agreements?
So I was going to suggest that, yeah, in terms of one of my tips for communication is that it might be a good idea to put it in your retainer agreement. And honestly, I think that just provides your clients with peace of mind, right? To know that, if Maya does get in an accident and I have my trial starting today, like what's going to happen, that at least they know you have a plan, that somebody will step in and notify them and get their instructions, and that they won't be weeks or months waiting to get their file, and then having to, suffer the consequences or prejudice from that.
And you listed three institutions: the Law Society, Law Pro, and there was a third institution.
Your clients, just your clients,
right?
Yeah.
I'm going to also add a fourth institution for many of us lawyers, which is Legal Aid Ontario. And Legal Aid Ontario should be, if you have a high volume or even a low volume legal aid practice, legal aid needs to be contacted right away in order to ensure a smooth transfer of certificates and to have the name of your administrator connected with legal aid.
Yes, 100%. And that I think I had mentioned that you may want to go above and beyond, and legal aid is one of those areas where you'd want to do that, or notifying the court as well that you're, especially if you have hearings coming up or have a busy trial schedule, etc. But yeah, that's a great point.
Okay, and just to clarify, this doesn't apply to situations where, for example, there's a breakdown in the relationship between the lawyer and the client, right?
No, it's really just a plan for the unexpected. So a sudden reason why you are no longer able to practice. And again, that could be temporary. Like you could have, be in the hospital for a month and then can come back. But in that month, as you know, you're going to have clients whose needs need to be met. And so at that point, that's why someone needs to step in and say, Maya's not going to be able to help you, unfortunately, for at least the next month. And so here's your options, right? So yeah, it's really like I said, at the end of the day about safeguarding your clients. And as lawyers, we all have a duty to do that. So this is just to help protect that even further.
And so that would apply also for those who go on mat leave?
So a succession plan is primarily for those who go on mat leave because that's more for planned absences. The client contingency plan is really more for sudden or unexpected absences. And so that's why I always say that compliance is a floor, not a ceiling, because it's, the client contingency planning requirements are minimal and they ensure some minimum protection for your client. But as licensees, I think it's important to think about your overall preparedness. Like, for example, I think everyone would have been happy if they had a pandemic preparedness plan before the pandemic hit us. And we didn't, because I don't think anyone anticipated that would happen, which goes to my point that really anything can happen. And so it's best to prepare for that. But yeah, if you're going on a mat leave or you're planning for retirement, then it's really about what you want to do with your practice in the meantime and thinking about that. Like, do you want, and if you're on your own and going on a mat leave, maybe you do want someone to come in and take over for that year or 18 months that you're off. Or if you're retiring, maybe you want to start thinking about mentoring a junior and having them take over your practice. But that's broader succession planning isn't actually required by the Law Society. What's required is just those three requirements. Yeah, the administrator doing those three things.
Now let's talk then about the scary part, which is non-compliant. So
Yes.
what will it look like?
Yeah, so like other things, failure to other administrative requirements, a failure to report annual compliance with the contingency planning requirements can result in an administrative suspension. If you are audited and have not complied with the Law Society, enforcement is sort of the last circumstance in which they'll go. It's really aimed at supporting compliance. So it'll be the penalty will be supporting you through advice, through guidance, through education, as opposed to enforcement or discipline. Enforcement's really only going to be considered in circumstances where a licensee completely refuses to comply with the requirement. And again, there's a difference between refusing and not being able to. So if you're not able to find an administrator, you can reach out to trustee services and they will help you. So that's not necessarily you not wanting to comply, it's you having a difficulty complying. And I know for some remote locations where there isn't a big network of licensees, it may be quite difficult to find somebody. And if you don't have, a primarily electronic filing practice system, then it's going to be even harder because you will need your administrator to physically attend your office. And if you're in a very remote location, that might be hard to do if you don't have many licensees in your area.
Kelly, I think you also had some practical tips that
Yeah.
you share.
Yeah. So just a couple of things. So I have some for planning licensees and some for the administrators. So in terms of planning licensees, the first one is really just to appoint a qualified administrator. So obviously you're required to appoint a licensed lawyer or paralegal, but I would encourage you to consider other factors. So like I said, if you have only a paper-based filing system, you are going to need somebody who physically can visit your office and help return or transfer client files and funds. Or if you have a trust account, because not all licensees have a trust account, you should ensure that your chosen administrator understands the trust accounting requirements, because they can be quite difficult to understand if you've never had or operated a trust account before. And then the other thing I'll mention is paralegal scope of practice, because a lawyer can appoint a paralegal to be their administrator. But if you want them to do more than the minimum, so for example, thinking in a criminal context, maybe you'd want them to seek an adjournment application. If it's before a certain level of court, a paralegal can't do that. So then you're looking at appointing a lawyer administrator. And again, that would be something extra to add, but I'm just thinking different practice areas, like you said, notifying Legal Aid Ontario, things like that you might want to consider including in your plan. So just keeping in mind, if you're appointing a paralegal, that they are limited in terms of their scope of services. And as I said, if you're having trouble finding an administrator, reach out to trustee services. You can do that through LSO Connects. So you can click on the trustee services tile and submit an inquiry form. And ultimately, if a suitable administrator cannot be identified as between you and trustee services, the trustee services department will work with you to put a plan in place and facilitate access to your trust account. So we are here to support you is basically the message. You're not alone in this. And I know as somebody who works, on your own solo, it is, part of the reason why you might be doing that is you don't trust as people to kind of be a part of your practice and deal with the money piece and all of that. So it may be difficult, but I would first start with your professional network and think about who would be, and maybe do a buddy system, like I'll be your administrator if you be mine, and try to do it more collaboratively that way. But of course, the Law Society is always here to support if you need any assistance. The second one, and I think this is a really important one for the planning licensee, is to really organize and have a communication plan. So part of the narrow role of the administrator, the reason behind that was to really limit professional liability, because nobody wants a claim coming out of being an administrator. And so that really entails that the planning licensee have organized files and an active client file list or another similar document that has all the information your administrator needs, so that they don't have to look through files. Because the minute they start looking through files, there could be a conflict of interest. They could have already potentially prejudiced the client's matter, etc. So you really want to make sure you have, and we have, as a bonus tip, we do have an active file chart if you don't have one yet, that you can download from the Law Society. It's, I think, an Excel format. But basically you would have like the client's name, their contact information, if there's any critical deadlines or hearings coming up, that if you have, you could include sort of the last trust balance, or if you have a separate document with that, that's fine as well. But something so that, and priority as well would also be important, so that the administrator knows, okay, I got to call these clients first because their hearing's a month from now, and they're going to need legal representation ASAP. So I would definitely make sure you're organized. As Neha said, to include the information in your retainer agreement or engagement letter, because it will help your clients and your administrator. And then drafting a letter, or having a letter or an email template that your administrator can use to notify clients. And again, the Law Society has a template for that as well. So you can use our template and customize it as you'd like. So you don't have to start from scratch. And then the third tip would be with relation to trust accounts. If you do have a trust account, talk to your bank early, as soon as possible, really, to find out what steps you need to take to authorize your administrator to access your trust accounts. Because what we're finding is each bank has their own requirements. And I would suggest using the sample power of attorney and providing that to the bank and saying, like, is this sufficient? And again, if the administrator is having problems accessing your trust account, they can reach out to trustee services, and trustee services will help facilitate that as well. That's it for planning licensees. For administrators, I think the key is, understand your responsibilities. That is pretty common sense, but review the bylaw and make sure you review the plan that's been prepared that you're going to administer, and ask questions of the planning licensee if there's anything that's unclear. The second tip I have is to assess your capacity and resources to fulfill this role. So in other words, ensure that taking on this role won't compromise the quality of service that you provide to your clients or the overall management of your practice. And that'll depend on, how many clients this licensee has. And you'll see in our checklist that we prepared for licensees, those are some of the things we've asked administrators to consider talking to the planning licensee about, like how many client files do you generally have, how big is your practice? Because if you're a sole and you're going to go help another sole and you have to notify thousands of clients, that may not be as easy to do. If you're supporting a non-lawyer steward in carrying out that, then maybe that's a little bit more manageable. But it's really important to sort of be honest and realistic with what your capabilities and capacity is, so that you're not impacting your clients while trying to help somebody else's. And then, like I said, communicate and avoid conflicts. So if you're an administrator, ensure your staff or family are aware of your appointment. It's important that they know who to contact in case you're suddenly unable to fulfill your role. Because you don't want a situation where one licensee thinks the administrator is still available, and then unfortunately the licensee falls ill and thinks that their administrator is stepping in, but the administrator passed away a year ago and nobody told them. So it's really important to communicate that. I would also encourage you to engage in regular conversations with the planning licensee. So just to make sure that you have all the information, you have all the resources, that maybe you want to discuss some steps that the planning licensee could take to facilitate your role. And that may even be, hey, do you have a non-lawyer steward that I could support, as opposed to carrying out all those steps on my own. And then to avoid conflicts of interest, like I said, it's really about being the planning licensee being organized and ensuring that you're not reviewing client files, because that could expose you to a conflict, which then could expose you to a potential claim, and nobody wants that. So I would recommend just following the LSO guidelines that we've created to help avoid that situation. And those are pretty much it. My only sort of, I guess, parting words is that don't wait until it's too late. I think the sooner you get on this, the better. Utilize the Law Society resources. I mean, even just as a beginning, use our template. At least you have a plan. Start talking to your professional network. Start connecting with people saying, like, I have this requirement, you have this requirement. Is there something we can do about this? Think about whether you do want a non-lawyer steward to do the actual steps and just have an administrator oversee and support them in that role.
And are the resources already available on the Law Society website?
Yes, they are. So if you just go onto the Law Society website under Manage Your License, you will see it, or you can just search the Law Society website for client contingency planning, and you'll find them all in one spot. So they're all there.
All right. Thank you so much, Kelly and
Yeah,
Neha,
no problem.
this session. It was a lot of information, but I'm sure it's
Yes.
very valuable for everyone who's watching this. And hopefully this is something that will assist many of us in organizing ourselves to fulfill the requirements that will starting January of 2025, coming up already. So
And I think the only thing I would also say is, I mean, if you have questions or if you want to connect with me directly, feel free. I mean, you can call the practice management helpline, speak to any of our counsel. You can also email me at kgerra@lso.ca. Happy to answer any questions you may have or direct you to the right department if we don't have the answers. So yeah, don't hesitate to reach out. We really are here to help and support you in understanding and complying with the new requirements.
perfect.
And for criminal lawyers who are looking for uh, someone to guide them in the right direction or to point them in the right direction to staff or to forums on the website, you can also email me, neha@chughlaw.ca.
I'm definitely going to email you now because you're going to be helping me with this. So you're going to be
I'm always late because I'm always late.
you're going to help me. You're going to be my planner for this.
Absolutely. Happy to do it. And those of you who are in firms, be good stewards. Reach out to your friends who are solos and see if you can help them. And reach out to your buddy network because we have to work together. We are so important for the criminal bar. Defense lawyers are very important, and this added layer of bureaucracy or work to do should not be a reason that stops us from practicing because our work is so valuable. This is just good business management.
100%.
It is just good practice. It is good for our clients. And so we should be working together as colleagues to make this happen.
Yeah, 100%. I think, I mean, contingency planning has always been recommended by the Law Society. And I think, unfortunately, the experience of trustee services is that many don't. And that has led to a lot of increase, especially with the aging bar with trustee services. So I always say, like, we're all in this together. So let's start the conversations and try to collaborate as best as we can and buddy up. So
Terrific.
Thank
great.
you so much, ladies, for your time and for the presentation. And I wish you a wonderful day.
Thank you.
Great.
Thanks so much. Bye,
Bye
everyone.
now.